All right.
No, we were going to look at question 2. One of these, there's one thing that's left for us to look at in this list of questions, isn't that right?
My Lord, you asked if we could look at question 2S.
Yes, 2S, which would...
Which I have here. The question is, I am considering a management buyout involving both a ratchet and a carried interest. What is the tax treatment under Schedule 22? Okay. The answer, the Inland Revenue and British Venture Capital Association have jointly issued guidance in the form of 2 memoranda of understanding concerning shares held by managers and carried interest. The first of these memoranda, my Lord, is entitled Memoranda of Understanding with BVCA on Managers' Equity Investments, which I think may be of some assistance, and I have the relevant paragraphs here. The second is on venture capital and carried interest, which I don't think is of any relevance at all.
Well, what I suggest is, if they may be of relevance, that you let Mr. Johnson see...
I don't have them. All I've got here is these 2 lines as answers.
Well, they don't give very much away on their own.
However, we've got them on our laptop over here, so my learned friend can look at them at home time if he wishes to.
Well, if you want us to look at them, we'll obviously have to have copies. But
if I could just tell you what it says about ratchets, if that would be of assistance.
Yes, as quickly as you can.
Yes, I'll just read it, my Lord. I'll not make any particular submissions on it. 6, ratchets. If the manager's shares are subject to ratchet arrangements which conform to 6.2a below, and I have that, the Inland Revenue accepts that the ratchet arrangement should be dealt with by taking into account, in determining the unrestricted market value, assuming the shares are restricted, otherwise the market value, of the manager's shares when they are acquired by the managers, and either Part 2, which is general earnings, or Chapter 2 of Part 7 ITPA will apply, if that value exceeds the amount paid for the shares. So, just if I may, what that means in practical terms is that whether they're restricted securities under Part 7 or not, if the value, including the ratchet value, is more than you paid for them, then that gets taxed when you get them, under general principle or under Part 2 if it involves a restriction. And then they go on to say, however, if the ratchet arrangements conform to all the conditions in 6.2 below, the revenue accepts that the arrangements will not of themselves result in any charge under Chapters 1 to 5 of Part 7. And accordingly, if all the conditions in Para 4, which are replaced by 6.2 below, are satisfied, then the revenue accepts the price paid by the managers to acquire their managers' shares shall be not less than the initial unrestricted market value. So the point about that being that the rest of the memorandum is all about, have you got these ratchet rights, these rights which will flower, for less than what they're worth? And broadly speaking, the answer given by the memorandum is that if you've paid the same amount for them as the venture capitalists have paid, then the revenue will accept that you've paid full value for them. For present purposes, the significance is in the passage I've just read out, which is that charges are by reference to the beginning, not what happens at the end. And if you've paid that full value, there's nothing else to pay under 3D at the end.
Yeah.
That's the significance. I can read out to you the conditions which were referred to, my Lord.
You need to get you further into it.
But I think it might be easier if we get this copied and hand it up at some stage before the end of the hearing.
Well, according to the inventory you gave us at the beginning, To look briefly to the inheritance tax.
But before that, my Lord, I just very quickly want to take you to the authorities about the significance of the frequently asked questions.
Oh, right, yes.
If we look in volume 4, which was out before lunch, divider 33, we find an extract from Benyon on statutory interpretation. It's the 5th edition. My apologies, my Lord, that the publication date sheet is not included here. I believe it's 2008, but it's certainly fairly recent. I'd like to draw your attention to the post-enacting history, section 231, the basic rule regarding post-enacting history. In the period immediately following its enactment, the history of how an enactment is understood by the profession forms part of the contemporanea expositio and may be held to throw light on the legislative intention. The later history may, under the doctrine that an ongoing act is always speaking, indicate how the enactment is regarded in the light of developments from time to time. And then it comments on that. In the contemporanea expositio, the concept of legislative intention is a difficult one. Contemporary exposition helps to show what people thought the act meant in the period immediately after it was passed. Official statements on its meaning are particularly important here, since every act is supervised and most are originally promoted by a government department, which may be assumed to know what the legislation was. And then moving on to section 232. Official statements by the government department administering an act or by any other authority concerned with the act may be taken into account as persuasive authority on the legal meaning of its provisions. And the comment, this section of the code has been accepted as authoritative by the House of Lords. See R. and Mantilla. I'll take you to that in a moment, my Lord. In a later decision, the Divisional Court followed the wording of this section when answering a question from justices as to the weight they should give to Home Office guidance regarding closure orders under the Antisocial Behaviour Act, section 23B. And you'll see footnoted the references. My Lord, the reference to Montilla, you'll find the case in volume 3 at tab 24. And the passage in question, I won't detain your Lordship very long on this with the head note or anything else. If I may take you straight to the passage in question so you can see it, I don't think it throws a great deal on this. It's paragraph 40 on page 3153. And it is merely the second sentence. There is some authority for the view that official statements by a government department which is responsible for administering an act may be taken into account as persuasive authority as to what the act means. Benyon, page 597, and then it's held that that has no application in the context of this particular decision. So that's mere dicta.
It's very strange to me. I mean, I thought it was against everything to say that the meaning of an act could be controlled by the executive.
My Lord, it's far from that. And if I may take you to the other relevant authority, the Chief Constable of Cumbria, which is in volume 1 at tab 10.
That one?
10, my Lord. The point is that these passages from the Revenues Manual are merely persuasive. They're certainly not binding in any sense. But, my Lord...
If they were against you, I don't think you'd be making this submission.
I would say that they would be wrong if they were against me, no doubt. But for all the reasons I've already given you, I say...
I know, of course.
Of course, my Lord, I accept that. Tab 10, page 1407, the head note. The Chief Constable sought a closure order pursuant to Section 2 of the Antisocial Behaviour Act 2003. By Section 2, subsection 3, the Magistrates' Court could make such an order if it was satisfied that A, the premises in question had been used in connection with the unlawful use, production or supply of a Class A drug. B, the use of the premises was associated with the occurrence of disorder or nuisance to members of the public. And C, it was necessary to make an order. At the hearing, the Justice's attention was drawn to guidance published by the Home Office in relation to the 2003 Act. The view expressed there was that it did not need to be demonstrated that the disorder or serious nuisance was associated with or resulted from the drug use or production or supply, simply that both were present at the same premises. The Justices rejected that view, holding that the disorder had to result from the unlawful use, etc. They also held that there needed to be evidence of disorder occurring during the relevant period of 3 months specified in section 110. And the Justices concluded accordingly over the page on appeal, held dismissing the appeal, that in general official statements by government departments administering an act could be taken into account as persuasive authority on the meaning of its provisions, but there was no presumption that the views contained therein were correct. And that is the second citation which Benyon gives. If we turn to page 1411 in the judgment of Mr. Justice Lord Jones at paragraph 12, the second question concerns the extent to which it may be permissible to have regard to the Home Office guidance. The Home Office Antisocial Behaviour Act 2003 Notes of Guidance states that it's designed to help those who are responsible for the exercise of powers under the Act to use the powers effectively and efficiently, to see the use of the powers in the broader context of tackling drug problems, and to understand the implications of the powers as they relate to affected persons and the communities in which they occur. It states at para 1.12, this guidance is designed principally for the courts, the police, teams involved in tackling antisocial behaviour. The Justices referred to the guidance when reaching their decision, however they clearly disagreed with it, what it had to say on the issue raised by the first question in the appeal. And then moving on to paragraph 16, the second respondent submits that the guidance should not be taken into account. In paragraph 17, it is of course for the courts and not the executive to interpret the legislation. However, in general, official statements by government departments administering an act or by any other authority may be taken into account as persuasive authority on the legal meaning of its provisions, citing Benyon. And then there's the decision on this particular case.
Leaving that tract of authority aside, is there any authority about in and revenue practice statements and the extent to which they would be regarded as authoritative, or should be attached to them?
There is no authority that I'm aware of, except, my Lord, occasional statements in proceedings before the Special Commissioners in the past, to the effect that statements of practice and or extra statutory concessions are of no concern, they're not within the jurisdiction.
What about page 703 of Benyon, example 2322? That's closer to home, isn't it?
Yes. That's what I've had in mind, actually.
That is indeed
yes, it is rather like that.
the sort of persuasive weight, my Lord, which these statements could carry.
It's certainly very odd. I think you're entitled to say this, to have these questions answered in one way, and yet to find in this case the revenue is seeking to argue the contrary. So it appears.
So it appears, my Lord, and particularly, if I may say so, and I bow to my learned friend and those behind him if it's so, but I've not been able to find it anywhere in the other guidance which is decisively against us. And the points that I drew your attention to this morning are decisively in our favour. Obviously, it is for your lordships, in the context of this decision, of this particular problem, to take these matters into account or to decide what weight to give them. And there is, of course, as my Lord Roger has observed, a grave danger in giving too much weight to guidance issued by the executive, lest Parliament be circumvented and the executive implement by fiat whatever it wishes without parliamentary control. But against that, it seems obvious common sense that the department which was responsible for putting a measure through Parliament must have known at least what it thought the thing was doing when it promoted the legislation. And
I suppose you would say that the significance is to be enhanced when there's a contrast between what they have said in a statement and what they seek to argue before the courts.
but perhaps, my lord, I think that's the case here. Whether it will be so in all cases, I would hesitate to go that far. The significance here is perhaps linked to the observation that Lord Walker made this morning about this being the first case of this sort and there being no others in the system. And we say, well, that's not surprising if the revenue adhere to their published statement in those other cases. We don't know whether they do or they don't, but if they didn't, then I would expect there to be other cases before the courts.
How long has the answer been published in that form?
That form was published at least not later than the 1st of July 2003, when the ink was not yet dry on the finance bill. It was still a bill, albeit it had completed its stages through the House of Commons by then. But it stayed in that form as frequently asked questions on the Revenue's website, with additional ones being added to it over a period of years. And then more recently, they came off the website and instead the Revenue published a much fuller employment-related securities manual, which included most of what was on the website, but not that specific statement in those specific terms.
So they're not still maintaining that position publicly?
It's not in those terms, but you can spell it out of the way in which they talk about rights and restrictions in the manuals, all of which is online, my lord. If you want to spend hours and hours trawling through it. What I can say about what's online, there are some very helpful examples which illustrate how the provisions we've been talking about this morning work. I hesitated to put them in front of your lordships because examples can take up a lot of time and sometimes don't assist, but I can recommend them to you if you found anything of what I was saying this morning difficult.
Your index paragraph, the front of volume 4 to item 38 gives a link to something. What is the December date? That can't be this year?
I don't know with precision.
Was it December 2005, reading along the line?
I'm guessing it's 2005, but I do not know.
Yeah.
The version we have here is certainly fuller than the original version. There was a paper copy of the original version we found in Simon's Weekly Tax Intelligence for covering the 1st of July 2003. And the questions on chapter 1 stop at question L, I think. So question M, I know for a fact, is later than the 1st of July 2003. But this is archive material, and we've not been able to ascertain with precision when it was pulled from the web, but certainly K was there right from the beginning. And M was there before the end of 2003, before these events occurred.
So M was there
sorry, my lord.
M was there before the end of 2003, you say?
M was there before the events we're concerned with.
That's November 2003.
Yes, it was towards the end of the summer. It arrived, from my own personal recollection, my lord, as best as I can. What I can also say is that although in this format these question and answers aren't there anymore on the Revenue website, nowhere has it ever been said that they were incorrect, or that people couldn't rely on them, or that they were being formally withdrawn. Simply when the employment-related securities manual was published, in effect they were superseded and they disappeared. And much of the material in the Employment-Related Securities Manual, the narrative, is paraphrasing of these questions and answers.
Yes, well, where do we go now?
Where we go now, my Lord, just before I leave part 7, if I can just sum up what I said in, I hope, one or two very short sentences. Market value in part 7, used in the same way throughout part 7, because that's what the draftsman of chapter 1 tells us we have to do, because the provisions interrelate in the way in which I explained this morning. That market value in that context assumes, and we can see this from chapters 2 and 3, that it takes account of rights which are personal rather than rights in rem, or put another way, rights which are collateral rather than embodied in the defining documents, rather than embodied in the defining documents of the security. So that assumption, we say, is implicit in the way in which Part 7 works.
Now, it's said, I think, that the logic of that argument is it reduces the tax charge under 3D, in this case, to nil.
It reduces the tax charge on disposal, in this case, to nil, but on acquisition, 3C would bite. And of course, if it were appropriate, and bear in mind, Mr. Gibson paid a lot of money for the benefit of these shares and this agreement. By way of background, you'll see when you look at the terms of the agreement that the net asset value and notional goodwill provision has a figure of 1.3 million in it. By way of background, my instructions are the company was thought to be worth around about £1 million at the time. He paid £50,000. Now that's a pro rata for a very small minority interest. Normally a 5% interest in a closed company where there is no immediate prospect of sale would be very heavily discounted, maybe 60-80% to the pro rata of the value of the company as a whole. Now, all this is background, it doesn't decide the issue for you, but the point that I would wish to make is that if Mr. Gibson was to be taxed on these rights, the time to tax him, as with the ratchets which we've been hearing about from the BVCA memorandum, is at the beginning on what their value was then, unless either Chapter 2 or 3C pushes the tax charge towards the end.
Sorry, unless which pushes it
Chapter
towards...
2 dealing with restrictions, or Chapter 3 dealing with convertibles, pushes it towards the end.
Yeah. Well, it's quite an important point, just on the sort of general philosophy.
But on the general philosophy, and the predecessor...
What we don't have, of course, is a tax charge, in fact, because the transaction was entered into before the statute brought...
yes, but Chapters 3C and 3D, albeit in different wording, aren't completely new. There was, prior to those provisions, there were the provisions which were in sections 198, 199 and 200 of ITIPA. They were in force from the 6th of April to the 16th of April 2003. That must be something of a record for shortness, I think, my lords.
But some of these provisions, not all of them, go back to the Finance Act 1988, don't they?
And beyond, my lord. They go back to the Finance Act 1976 in origin, and the relevant provisions you'll find...
But just coming back to, I don't know if we're concerned with those, but the general philosophy, you say that Mr. Gibson should have been taxed at the beginning, but it would have been totally impossible to set a realistic value on the totality of his rights at the beginning, would it not?
Well, my lord, the whole principle of the passage I read out from the BVCA memorandum is that you can put a value on these things at the beginning, and if you can...
But I don't want to be told that what it says in the memorandum, but how can you put a value on it right at the beginning if we know that if Mr. Gibson leaves either because he commits a breach of his agreement or various other circumstances, he gets back £50,000. He gets back the money he put in without any interest or increment at all. How can you value his shares in those circumstances?
Well, my lord, what you can do is to say, in respect of the benefit of the agreement and how it affects the value of his shares, you can at least say, well, his shares, absent the agreement, will be valued on conventional valuation bases. And if that's a lot below £50,000, then he's paid more than that. That's a starting point. Secondly, as to how, at what figure you put on all these rights, and rights and restrictions which are personal to the individual are common in employment-related securities, that is the business of the shares evaluation division and the accountancy profession. I mean, how you do it is a
But it is it's the business of someone with a crystal ball. If you're trying to persuade us, just in general terms, of what is fair, isn't the general philosophy that if you can't work out what is a fair charge at the beginning, you wait and see, and tax at the end? I mean, isn't that one of the underlying principles?
No, my lord. And
No?
what I would say is that the principle that you tax at the beginning by reference to what you've got. An example is Abbott and Philbin, where there was an option granted over shares, but with restrictions by reference to leaving employment.
I'm sure you're not meaning to, but I'm trying to ask you really simple questions, and you're giving me very technical answers. And just the simple question is, if it is quite uncertain what an employee is going to get out of this arrangement, is it not fairer both to the taxpayer and to the revenue to wait and see and tax at the end? And that's a question you can answer without reference to authority.
And my answer to that, my lord, is not necessarily. It may depend on how it's framed. I can say that here, if Mr. Gibson paid a full price at the beginning, which reflected the chance that these agreements gave him, why should he be taxed on the benefit of that at the end? That would be unfair. That is at the heart of this case. If he's paid for this, or would have been taxed if he hadn't paid for it at the beginning, a full price for everything he's got, then it's got to be quite wrong that he pays tax on it again when he comes to realise the benefit of that, other than as a capital gain.
Well, I may have missed something. I hadn't thought that. I thought it was an alternative, either at the start or at the end. And this is a purely general thought, but I would have thought it's better to see how the whole thing turns out and tax at the end. And maybe he paid too much.
Well, my lord, as a general proposition, that may be so, but the scheme of the legislation is clearly not that. And I can point to both Chapter 2 and Chapter 3, which deliberately proceed on the basis that your taxation will be at the beginning and deliberately push forward towards the end, forward in time, the things that they tax. And it's clear from that the scheme of the legislation is, apart from specific provision doing that, the beginning is where it happens. And so Chapter 3D is designed to tax things which come in at the end, which aren't already there. So, for example, if an employee buys shares for 100 and that's their market value, and a couple of years later they've gone down to 50, and the employer, rather than somebody out there in the marketplace, says, I'll give you 100 for those, that's what you paid for them, I'll stop the loss for you. That would be a Chapter 3D event, because the shares are now worth 50 and the employer's paying 100.
Well, I think we have to make some progress because this time is running against us, rather. So you wanted to look at inheritance tax, did you?
I wanted to look at capital gains tax first.
And the purpose of this is what?
Because this is the rule we're looking at, and I want to show you that even within the capital gains tax rules, we are not necessarily looking at market value excluding personal rights. It's a very quick point, my lord, I hope. So, just before the adjournment, I took you to divider 37 in volume 4.
Yes.
This is section 272, and subsection 1 defines market value in relation to any asset, means the price which those assets might reasonably be expected to fetch on a sale in the open market. And then 2 is a provision which affects lotting. You don't take the value, split the value up between a series of assets if that would artificially or depress the value. And then section 273 deals with unquoted shares and securities. And subsection 3 we looked at briefly in one of the answers this morning to the frequently asked questions. This is the provision which says we bring in all the information which a prudent prospective purchaser of the asset might reasonably require if he were proposing to purchase it from a willing vendor by private treaty and at arm's length. So this is a statutory formulation which, in effect, clarifies the position post-Lionel so far as capital gains tax is concerned. And its relevance to the present proceedings is obvious, I would submit, in that at the point of sale, the reasonably prudent purchaser would want to know, is there a sale contract out there, and what's the price that these particular shares are specified at under that sale contract? Is there anything else out there that might affect what these particular shares are worth, whether it's within the description of the property or not? So the subscription we would say the things which the prudent purchaser would certainly be seeking, and of course within Mr. Gibson's provide, or hypothetically then ought to provide. Before leaving the taxation of charitable gains, there is a very brief point I want to make. I hope it's brief.
Sorry, I'm just trying to think my way through subsection 3. So it's information which would be relevant to the price in a hypothetical transaction of the asset in question. Would that be right? I
Yes.
mean, one is assuming that the asset in question are the shares held by Mr. Gibson, and it's information which would be relevant to a transaction relating to those shares, not the transmission of anything else. It's simply his right in the shares.
It doesn't answer the question of what's the property.
No.
But it does bear in that there was, at the point of valuation here, a coterminous sale contract on the table with an independent arm's length third party, and a price in that for the subject matter in question was in that contract. That is information which the third party would get. And he would get information, I think, about the subscription agreement, if I'm right, that it contains the terms of issue of the shares.
Yes.
My Lord, if I can take you to the additional bundle that was handed up this morning, and to the last divider. Typeface is not terrific on the second page in my edition. If you would like it cleaned up there.
No, I think we can make enough out of it. Which section are we looking at?
Section 18.
Oh, you need 18, do you? Right. 17 is not too bad.
17 is worth just noting in passing, that that imposes the general rule that where a transaction is not at arm's length, then capital gains tax purposes consideration to be taken to equal to the market value of the asset. And then section 18 deals with transactions between connected persons. In subsection 2, without prejudice to the generality of section 17 and subsection 1, a person acquiring the asset and the person making the disposal shall be treated as parties to a transaction otherwise than by way of bargain made at arm's length. So nothing exceptional there.
Are we dealing with a transaction between connected persons?
But we're not here, my Lord, but you will see the point I'm making in 1 moment. If we then go to subsection 6, subject to subsection 7, in a case where the asset mentioned in subsection 1 above is subject to any right or restriction enforceable by the person making the disposal or by a person connected with it, then where the amount of the consideration for the acquisition is in accordance with subsection 2 above and deemed to be the market value of the asset, that market value shall be A, what its market value would be if not subject to the right of restriction, minus the market value of the right of restriction, or the amount by which its extinction would enhance the value of the asset to its owner, whichever is the less. So here's a special rule. It applies when there is a right or restriction over an asset in somebody else's hands. In 7, we get a glimpse of what kind of right or restriction this might be. If the right or restriction is of such a nature that its enforcement would or might effectively destroy or substantially impair the value of the asset without bringing any countervailing advantage either to the person making the disposal or the person connected with it, or is an option or other right to acquire the asset, or in the case of incorporeal property, is a right to extinguish the asset of the person living by forfeiture or measure. The market value of the asset shall be determined, and the amount of gain accruing with disposal shall be computed as if the right or restriction did not exist. And my Lord, the importance of this provision here is that it shows that the draftsman of the 1992 legislation contemplated that rights and restrictions held by another could affect the market value of an asset. Moreover, that such rights or restrictions might, among other things, be an option or other right to acquire the asset. Clearly, in the draftsman's contemplation, these rights amount to be outside the asset, personal, and not in the realm.
Now, is that rule special to transactions between connected persons, or
It is, my Lord. But what it tells us is that the draftsman of the code considered that rights of this sort could affect market value of an asset, even though the right was not in rem. So I give my shares to my son. In a collateral contract, I take a right to reacquire them at a price. The draftsman contemplated that that might depress the market value of what was being transmitted, and says you've got to ignore it. Now, all I say on this is that it illustrates that in the capital gains tax code, the draftsman was not completely clear that market value was determined purely by looking at the rights that were in rem and could be affected by personal rights. My Lord, if I now may take you to the inheritance tax legislation.
Yes.
Just to mention, all those provisions we looked at have been in the capital gains tax code since 1960.
We're in the additional authorities bundle
We're
still.
in the additional authorities bundle again, my Lord, at divider 11, please. Here we see at section 160 the market value rule for inheritance tax. Except as otherwise provided by this Act, the value at any time of any property shall, for the purposes of this Act, be the price which the property might reasonably be expected to fetch if sold in the open market at that time. And this is the language which your Lordship will be familiar with in the estate duty legislation, going back to 1894, and is the language that the estate duty authorities, which we'll go to in a minute, were considering. And then, in these provisions, there are provisions about related property and then about liabilities. And then at 163, there is a provision as follows in subsection 1, where by a contract made at any time, the right to dispose of any property has been excluded or restricted, then in determining the value of the property for the purposes of the first relevant event happening after that time, the exclusion or restriction shall be taken into account only to the extent, if any, that consideration in money or money's worth was given for it. But if the contract was a chargeable transfer as part of associated operations which together were a chargeable transfer, an allowance shall be made for the value transferred thereby, or for so much as is attributable to the exclusion or restriction. The same point arises, my Lord. The draftsman of this legislation contemplated that contracts, albeit a smaller class of contract here, but contracts which restricted the freedom to dispose could have an effect on value, and provided that unless they were full value items themselves, they were to be left out of account. You will see in subsection 2, my Lord, where the contract was made before the 27th of March 1974, subsection 1 applies only if the first relevant event is a transfer made on death. Now the relevance of that, my Lord, is I've not been able to track down the origins of this provision beyond the Finance Act 1974, which introduced capital transfer tax. That suggests that this provision originated in 1974 and wasn't in the estate duty code. And I've certainly not been able to find it in the estate duty legislation.
Can you give a very simple example without taking time as to how 163(1) would work? What kind of thing are we talking about?
Well, this might be a provision in an employment contract or a collateral contract saying that an individual cannot dispose of shares so long as he's an employee.
And then he dies.
He dies, the market value is ascertained disregarding that restriction, unless he gave full value for it, which he may have done, in which case the restriction would reduce the value of the shares accordingly. Or may do, if it were a prohibition on restriction for a particular length of time.
I don't understand what you mean by giving full value in that context.
My Lord,
How do you give full value for that sort of restriction?
it may be that it's a stipulation of the terms of employment. Instead of being paid X, you're paid a lower amount. It may be that a cash sum has been paid. Whether it's full value, it will be a matter of valuation at the time the contract was entered into. If, for example, it were a traded option or something of that kind, you could identify what full value was very easily if it were a market traded right over a particular asset. But the quantification of it is not, and the quantification of full value in this particular context is not germane to the argument, my Lord. The point I'm making is that the draftsman here had it in mind that rights and restrictions which were not inherent in the asset could nevertheless affect their value, and is making special provision about them.
The point is slightly weakened, is it, by the opening words of section 160, which I don't think appear in 272 of the Taxation of Chargeable Gains Act 1992. You see, there it's just an absolute straightforward rule.
Indeed, my Lord.
Whereas here we've got except as otherwise provided by this Act, and one can see that one might say, well, all right, market value is X, but why should I have to be charged for an asset I couldn't dispose of? And then you get a special rule.
Yes, but section 163 doesn't give relief, my Lord.
No, it's dealing with a problem, though, which...
Well, it wouldn't affect market value. It simply has to be disregarded if it doesn't satisfy sub A. So the assumption is that it must be relevant for it to be worth disregarding. So it's not say, an express relief, which would be aptly described as except as otherwise provided by this Act. So this isn't a positive provision that you reduce the value. This is, don't reduce the value, save where you satisfy a condition, presuming that in those circumstances the market value is indeed reduced.
But you're asking us to assume that that applies to a purely personal restriction, are you?
Well, I am, my Lord, because it talks about a contract.
Well, it does, but there are two phrases you've used. One is a restriction not inherent in the asset, and then you've sometimes said a restriction that is not in rem. And I don't at the moment see that those two are identical, because if you have a share in a private company, all sorts of restrictions built into the article, that is both inherent in the asset and it's in rem. If two neighbours who don't like too much development, both with back gardens, grant each other a restrictive covenant that neither will sell off the end of the garden for building. That is not inherent in the asset. It's something that is imposed by agreement between them, but it's assuredly in rem. It's enforceable against the land. And then you have something that's purely personal. And do you accept that there is a distinction between those two?
I do accept that, my Lord. Quite. When I was using the phrase in rem in relation to the assets under consideration, I was echoing my Lord Hope's use of the phrase this morning to distinguish from personal rights, which are...
But I don't at the moment see that section 163 would bite on what we've called something purely personal, because it wouldn't come into, on the Crown's argument, it wouldn't come into section 160 at all. It's simply a personal obligation.
But if you had a contract which was, let's say, an option, which might be an option over shares, but is clearly not form part of the shares because it's not in the constitutional documents of the company, and it's by contract and it's in a close company, so that it would be, say, specifically enforceable, then surely it would be apt to say that that's a contract by virtue of which the right to dispose of the property has been excluded or restricted.
Yes, but as you say, if it's specifically enforceable, it is enforceable in rem. And the other side of the coin, of course, is that the option is itself an asset for capital gains tax purposes and for the purposes of death duties as well.
Indeed, my lord. I think all I'm saying here is that the draftsman here is talking about contracts which restrict freedom to dispose. Whether or not that sounds in rem in the sense that it's specifically enforceable, it may be outside the defining documents of the property over which it may be exercised. So in arriving at the market value of shares, it's clearly not an option to buy them, is clearly not part of the constitutional documents of the company. So in terms of the analysis below, that would seem to fall on the personal side of the line, even if specifically enforceable. Indeed, it may well be that many of the rights that were granted to Mr. Gibson in respect of Mr. Gibson's shares as defined would be specifically enforceable. All I'm saying about the provision here is that it's not essential that a contract such as is mentioned in 163 is part of or makes up the definition of the asset in question, and yet it can affect its market value. And I think that's as high as it goes.
Thank you.
Now, I think the next chapter is looking at some authorities, is it?
Indeed, my lord, it is. So if I can take you to volume 1 of the authorities and start at the beginning at tab 3 of volume 1. This is Jameson in the Court of Appeal in Ireland, and my lord, shall I leave you to read the head note?
Well, I wonder whether you could just take us fairly rapidly to the bits that really matter.
Right.
I mean, there's some
Very
dictum
happy to
presumably
do that,
here
my
that
lord.
you're looking at.
First, on page 221,
Yes.
to note there's a reference to some of the articles are set out there, and Article 11, which is at the foot of 221 and above on 222, provides that if the preemption rights aren't exercised, then a sale can be made in the open market,
Yes.
an unrestricted sale.
So it's a preemption written into the articles. Yes.
And then Lord Ashbourne at page 226, towards the foot of the page, where he says 4 lines up from the foot of the page, each side rushes to an indefensible extreme. The argument of the Attorney General, which seeks to brush aside the articles and to vest in the executors of property which Henry Jameson never possessed, or describes the Finance Act, the power making a new subject matter. The argument of the defendants clings desperately to the articles and gives really no adequate significance to the words of the Act, requiring the commissioners to estimate the price which the shares would fetch in the open market. The solution lies between the two. The Attorney General must give more weight to the articles and the defendants to the statute. It requires no tremendous imagination to conceive what a purchaser will give in the open market for Henry Jameson's shares as Henry Jameson himself held them at his death, for the right to stand in his shoes. And that's the first place that phrase comes from.
Yes.
On page 230, we're now in the with Lord Justice Fitzgibbon.
Halfway down page 230.
And halfway down the page, my lord, there is the passage which starts, the price was to be that which a purchaser would pay for the right, quotes, to stand in the shoes, in Henry Jameson's shoes, with good title to get into them and to remain in them, and to receive all the profits subject to all the liabilities of the position. And then the next paragraph, but that property, like all property that I know of, except perhaps the gold coin of the realm, has its incidents advantageous and disadvantageous. These include the operation of the articles so far as they are legal. And my lord, I will say they also include the terms upon which the shares are issued so far as they're legal. And he goes on, since the First Companies Act, property of countless value has been created under Articles of Association and has passed by transfer and on death. Since the Finance Act, it has been valued and assessed for estate duty until this case. I am not aware of any attempt made by the Crown to enhance the value for the purpose of the assessment above the value to the holder. So it's the value to the holder we're concerned with. But this would be the effect of estimating the value under Section 7.5 upon the assumption that any depreciating incidents affecting the property, again, in the hands of the holder while he lived, were to be left out of account in determining the price which an imaginary purchaser would give for it in a supposed open market.
Yes.
And then, my lord, in a passage which has been off-quoted in at page 238. Five lines up from the foot of the page, if I were obliged to ascertain their value from the first section of the Act alone, without reference to Section 7, I would hold that it was the sum that Henry Jameson would have obtained if he could have sold and transferred the shares, in the words of Clause 11 of the Articles, to any person and at any price, the purchaser to have the same rights therein and to be subject to the same liabilities as himself. I need hardly say that this sum would be different from the £100 per share at which the fair value is now fixed. The dividend of 20% per annum paid for years and likely to continue would attract men who buy securities to hold as an investment and not to resell, especially as the purchaser would always be at liberty to transfer to a son or a brother. On the other hand, the price would not be as high as that of a security equally good in other respects that could be disposed of at any time in the market. So that's his lordship's view in the light of nature. And then he says, turning to the 7th section of the Act, I find therein the very test of value which I should have applied in its absence. And this is the passage which is off-quoted in the subsequent authorities from that point onwards. The principal value shall be estimated, etc. The Attorney General and the defendants agree in saying that in this case there cannot be an actual sale in the open market. Therefore, argues the former, we must assume that there is no restriction of any kind. My objection to this mode of ascertaining the value is that the property bought in the imaginary sale will be a different property from that which Henry Jameson held at the time of his death. The defendants, on the other hand, contend that the only sale possible is a sale at which the highest price will be £100 per share, and that this ought to be the estimated value. My objection is that this estimate is not based on a sale in the open market as required by the Act. Being unable to accept either solution, I go back to my own, which is in strict accordance with the language of the section. I assume that there is such a sale of shares as is contemplated by Article 11, the effect of which will be to place the purchaser in the same position as that occupied by Henry Jameson.
Now, just the last declaration at page 240, he's suggesting a declaration that the principal value is to be estimated at the price which the shares would fetch if sold in the open market on the terms that the purchaser should be entitled to be registered as holder and take and hold them subject to the provisions of the articles, including those relating to alienation and transfer of the shares. And that's really as far as this case takes you, isn't it?
It is, save, my lord, I would say that if I'm right, that the agreement here contains the terms of issue of the shares, then I would submit that there is no reason why this principle should not apply to those terms of issue to the extent that they're found in the agreement rather than in the articles.
So you're saying that we should add in, taking the facts of this case, a subscription agreement?
If I'm right, that it contains the terms of issue. And
But
that those have authority under the articles.
Yes. But the purchaser's not going to have any position under the subscription agreement, is he?
Well, my lord, that's right, but as we'll see when we look at the subsequent authorities, if the rights come to an end because of a disposal, then the correct approach is to value the asset as though the hypothetical purchaser could get the benefit of such rights as the propositors had before they came to an end. And we'll see that in particular in Alexander.
So he doesn't stand in the shoes of the person.
Well, he does, my lord. So in the present circumstances, what one would say is, if I may, I'm sorry I interrupted you, that the person standing in Mr. Gibson's shoes would take all the rights which Mr. Gibson, under the agreement, was entitled to.
But which Mr. Gibson would not have had after the agreement, after the transaction was over. I mean, he's standing in the shoes, yes. I mean, you say as these shoes were immediately before the transaction took place.
I say at the time, and of course one of the incidents of at the time is the sale agreement as much as the subscription.
Yes.
But the one represents the fulfilment of the other, so far as Mr. Gibson's shares.
It's hard to see, I don't want to get too far into the facts just now, but it's hard to see how it's of any interest to the purchaser what happens between Mr. Gibson and his the other shareholders. He's purchasing the entire share capital of the company, and he's paying a figure
That's
that's
the actual purchaser, but the hypothetical purchaser is only getting Mr. Gibson's shares and the rights attaching to them. He gets them at the same instant of the sale, so he gets the benefit of the sale agreement as well. Because that's what Mr. Gibson's shares have got the benefit of at that time. But if you ask the question, what would happen, say, if the contract, the sale agreement, had been a contract with a delayed completion, and what interest might somebody have if they were acquiring a second before the contract was entered into, then they're very much interested in the rights in the subscription agreement, if I'm right, that they are the terms of the issue. And if they can stand in his shoes in relation to those rights, if that's the correct way to view the valuation, that tells us what those rights were worth to him, and that's what we're trying to find.
right. Well, shall we move on? We don't. Time again, I've said several times, is moving against you. We're moving fairly slowly. Can we get to the next authority?
Salverson's trustees, the relevant passage is in Lord Fleming's speech at page 391.
Which tab are we at?
If I can leave you with the reference, my lord, I'll move on to the next authority. It's
yes.
tab 25,
25.
page 391. Leaving you with that reference, my lord, if I may go to the next authority.
This is at 391. Sorry, I'm just trying to just to get the.
It's Lord Fleming, it's 392, I think. It is Lord Fleming.
25.
Right-hand share column of Lord Fleming.
Sorry, I beg your pardon, my lord. Lord Fleming starts on 389.
Oh, I see, yes.
And then on
Lord Fleming twice, yes.
391, the relevant passage, start in the right-hand column, the sentence which starts, in these circumstances, if the Articles of Association be complied with, etc.
Yes.
Yeah.
Coming all the way down to the end of that block of text which ends with the words limited extent.
Yeah, thank you.
Yes. Well, it looks very close to what we've just been looking at.
It is, and in Crossman, which is the next authority, which was in the House of Lords, we will see that they're both approved. And this is in volume 2 at tab 13. And if I may take you to page 40 first, my lord.
4-0.
40, my lord. Towards the foot of the page, underneath the reference to Borland's trustee and Steele brothers, picking up there, this is Viscount Hailsham, it is, as the learned judge there states, the interest of a shareholder in the company measured by a sum of money for the purpose of liability in the first place and of interest in the second, but also consisting of a series of mutual covenants entered into by all the shareholders inter se in accordance with section 16 of the Companies Act 1862. The contract contained in the Articles of Association is one of the original incidents of the share. Emphasis on one of. As I hope to make good later, we say the terms of issue to be found in the subscription agreement are also incidents. Then on page... Sorry, my lord.
Yes, that's all right, yes.
Page 42, still with Viscount Hailsham. And his lordship identifies the difficulty actually with all these cases, and so we see coming about 10 lines down page 42, but the purpose of section 7 subsection 5 is not to divine the property in respect of which estate duty is to be levied, but merely to afford a method of ascertaining its value. And at the foot of the page, his lordship says in the last sentence, I think that full justice is done to the meaning of the subsection if the property to be valued is determined by the earlier sections, and section 7 is treated as being merely a statutory direction as to the method by which the value is to be ascertained. In order to comply with that statutory direction, it's necessary to make the assumptions which the statute directs, etc. And then, my lord, if you come down to the next sentence, on the other hand, the effect of the construction which I am putting upon the section seems to me to be the only one which does enable the provisions of sections 1 and 2 of the statute to be carried into effect, and which ensures that the property in respect to which estate duty is levied shall include all that property which passes on the death of the deceased, and not merely such part of that property as could be disposed of in the open market. So the valuation exercise is not confined to that part of the property which could in fact be disposed of in the open market. If it can't be disposed of, you have to assume that it could be and put a value on it accordingly. For these reasons, I think the decision of the majority of the Court of Appeal was wrong, and that the cases of Jameson and Salverson were rightly decided. This is sufficient to dispose of the principal point in the case. So this appears to be at least part of his lordship's ratio. And of course, in Mr. Gibson's case, whilst it may be that the shares, after the shareholders' agreement has been fulfilled, the shares can carry on without the agreement is as nothing without the shares. So it's in Mr. Gibson's hands, it's valuable, but an element of that value, nearly all of that value can only be realised if he holds Mr. Gibson's shares as defined under the agreement, so far as he's concerned. And this passage I would submit is endorsed by Lord Roach at page 71 a little later on. Then, turning to page 45 in Lord Blainsborough's speech, at the foot of the page, the last indent, to no more than two characteristics of Article 34 need I specifically refer now. The first, surely unusual, is that the article discriminates between the male and the female holders of the ordinary shares. I'm just pausing there, a strangely personal and arbitrary distinction. And then on the next page, the first indent, the first characteristic of the article is perhaps for present purposes illuminating only. The second is important, and this talks about the preemption provision, and coming down the page you'll see a reference to Jameson's case. Just above halfway down the page there's a reference to Jameson's, and picking up there, it is only by agreement, it is important to note this, that the article is and remains binding. It may at any time by special resolution, as a deed is in terms provided by subclause 16, be altered in any and every particular. An inalienable characteristic of the regulations of the article, all important, as will be seen presently, when its relation to the Finance Act comes to be considered, is that these regulations are maintained and may at any time be abrogated by the agreement of not necessarily more than 3/4 of interest of the holders of the ordinary shares affected. So his lordship seemed to think it relevant that the restrictions, the provisions in that case, albeit in the articles, reflected agreement between the members and were at the mercy of not less than 3/4. As we'll see, if I'm right about class rights, then so far as Mr. Gibson's shares were concerned, his rights were not at the mercy even of that number. And then I think we find his ratio on page 48, where the passage starting at the top of page 48, he sets out the question, and then just beside his name in the margin, it is almost a case of statuchitis. The figure embodies what Mr. Justice Finlay calls the Jameson principle, now 30 years old, approved since in Scotland, and that's Salveson, and in the Irish Free State nowhere questioned, and acted upon by the revenue authorities all along. Next, on page 50, and here references to the property, on page 50, paragraph number 2, towards the top of the page, such, quotes, property may include many items over which the deceased had no power of disposition while he lived, and over which his executor had none after his death. So again, the fact that Mr. Gibson can't get rid of his rights doesn't mean that they're not something which can be valued and brought into the value of the asset. At the foot of that page, if the property has passed, then subject only to a case covered by section 3, no existing contract with reference to the property, although it be binding on the deceased's estate, has any influence upon the Commissioner's estimate of the price which in the open market the property would fetch. My Lord's, just pausing there, I think we've seen that the provisions for capital transfer tax in 168 may be slightly different now. And then on page 52, you find Lord Blainsborough quoting from Lord Justice Fitzgibbon in Jameson, the passage which, although not in terms saying stand in the shoes, says much the same thing.
In its full and ample manner, is that the...
And then Lord Blainsborough on page 53 discusses the reasoning of Chief Baron Pallas in the Jameson case, and says that he thinks that in effect Lord Justice Fitzgibbon was not differing to any great extent from him. And the top of 54 endorses Lord Justice Fitzgibbon. Then on page 56, a passage in which Lord Blainsford tries to elucidate the positions, starting at the second paragraph. May I elucidate this position by an illustration so drawn as to have regard to the regulations in this respect governing the ordinary and preference shares respectively of the company. Let it be supposed that a deceased person had in his lifetime purchased 2 jewels from a dealer in Hatton Garden, one a diamond brooch, the other, shall we say, a string of pearls. The pearls an out-and-out purchase, but the brooch purchased on the terms that if the deceased retained the jewel at his death and died without making it the subject of a specific bequest, the dealer was to have the right to purchase it from his legal personal representatives for, shall we say, £1,000. The deceased died intestate, retaining both jewels. At his death, the price obtainable for the brooch in the open market is £3,000. This too was the value of the pearls. The dealer claimed the brooch from the administrator, as he was entitled to do, at £1,000, and it was handed over to him on payment of that sum. In these circumstances, what was the principal value of the brooch? Like the value of the pearls, it was, I suggest, undoubtedly £3,000, and for the reason that the dealer's preemption price was not a full consideration protected by Section 3. So that seems to echo the provision that we saw, the restriction on the right to dispose in the inheritance tax legislation. So far, the analogy between the brooch and the ordinary shares here is complete, just as is that between the pearls and the preference shares in the company. But there, so far as concerns the ordinary shares and the brooch, the analogy ends. The preemption right over the brooch never comes within the purview of the commissioners at all, for the reason that the right does not burden the brooch in the hands of its notional purchaser. But to the ordinary shares in the purchaser's hands, the preemption rights continue to attach, and affecting the value of the shares as they do, must be duly discounted by the commissioners in their estimate of the price a purchaser will give for them. And, my lords, it is at that point, more perhaps than at any other, that I find myself in accordance with the Jameson principle. And of this, my lord, what we would say is that if we're right that the rights contained in the subscription agreement set out the terms upon which the shares were offered and taken up by Mr. Gibson, then the hypothetical purchaser must be presumed to have the benefit of those rights in a market valuation of those shares, and is within the principle set out here.
You say he must be assumed to have the benefits of those rights at the time of the transaction.
At the point of valuation, my lord, yes. Here, the transaction is also the point of valuation, yes.
Sorry?
Here, the transaction is also the point of valuation.
Yes, yes.
Yeah.
So here, the example of Brains was given, the purchaser is presumed to have purchased the shares with the same preemption right attaching to them. Is that right?
Yes. Something which is impossible, in fact.
Yeah.
But it must be presumed to have happened for the purpose of the valuation exercise.
Well, why is it impossible to
Well,
imagine
it's only impossible, my lord, if the preemption rights aren't actually exercised against the estate.
Yeah, but it could be continuing. I mean, it could be written in preemption rights in shares in a private company, not exercised on this occasion, but nevertheless binding any future holder of the shares.
Indeed, they would, my lord. But the point here is that at the point of death, one is being directed by this approach to ascertain what the hypothetical purchaser would pay to acquire the shares on the date of death, and not be subject immediately to the operation of the preemption rights. Because, of course, by virtue of the death, the preemption rights are triggered. But for this exercise, you ignore that in deciding what he would pay. You have to assume that he stands in the shoes of the deceased as though the deceased hadn't died. insofar as that triggers the preemption rights.
Yes.
My lord. Page 62, very briefly, at the foot of page 62, Lord Russell, who is in the dissenting minority, I quote this passage because it's in my learned friend's written case at paragraph 9, where he suggests that it's the appropriate formulation. And I quote it as a word of caution because it seems to be the basis for a dissenting view. It may or may not be correct, but it needs to be treated with caution, and it's the sentence that, beginning at the foot of the page. It's not a question of ascertaining their actual value or their true value or their intrinsic value or their value in some particular person's ownership. The value to be ascertained is their statutory value. I hazard to suggest, my lord, that it's not actually very helpful anyway. If I may then take you to page 71, my lord. And here, Lord Roche, in the first paragraph, says, the case is one of manifest difficulty, but I have arrived at a definite conclusion that the appeals should be allowed for the reasons expressed by the Lord Chancellor, which I've taken you to previously, my lord, in particular indicating what I thought was the ratio of the Lord Viscount Hailsham's decision. And then on page 73, Lord Roche, the last full paragraph on that page, it is also said that the shares to be valued are shares which, owing to their essential nature as created or defined by the articles, are worth no more to a buyer than the prescribed price, and that they must be valued at that price. With all respect to those who hold this view, I think that the Lord Chancellor, that a great deal more passed on the deaths of the deceased shareholders than the obligation to transfer shares at the prescribed price. For example, the right to hold them and the right to leave them to others so that they in their turn might enjoy the prosperity of the company were rights of great value. And the notional purchaser must, in my opinion, be regarded as notionally acquiring on his purchase those rights amongst the other rights connected with and going to make up the shares. That phrase, my lord, other rights connected with, is not confined to the articles. It echoes what Viscount Hailsham said at page 40, and bearing in mind that we are here concerned with rights connected with Mr. Gibson's shares, we say that they fall squarely within that reference. And then his lordship goes on, it seems to me to be important to remind oneself that section 7 sub 5 of the Act is simply a provision for estimating by means of an hypothesis the value of property which is passed otherwise than by an actual sale and transfer and may be incapable of so passing. So the fact that Mr. Gibson cannot transmit his rights under the shareholders' agreement doesn't rob them of their significant value for this purpose. You have to work out what somebody would pay for them if they could get into his shoes and enjoy them. But the section has to be applied and can be applied to all such cases. As to property which by its inherent or essential nature cannot be actually sold or transferred, the application of the section was explained as I should like to explain it by my noble and learned friend then, Mr. Justice Russell, in the case of Recastle. The learned judge says, next, how is the principal value of that property to be ascertained? The machinery provided by the Act is section 7 sub 5, supplemented to some extent by subsection 8. That machinery does not exactly fit the present case because from the personal nature of the provision, the benefit of it could not be sold at all. An outside purchaser would not obtain delivery of the goods. Nevertheless, the machinery must be made to fit, and I think it can be made to fit. It was made to fit in the Irish case of Jameson, the value cannot be ascertained by reference to market price because there can be no market. And Lord Roche continues, the learned judge then proceeded to suggest or direct how a hypothetical market price should be arrived at. In substance, the process suggested seems to have amounted to an estimation or assessment on general business lines of the value of the thing or property in question to a person who could enjoy it, even though it can't be transmitted to them. And note there the references to property which is purely personal in nature. The principle, therefore, we say applies to the shares with the benefit of the agreement in this case. Although only Lord Roche deals with the nature of personal rights in this decision, as we'll see when we look at Lionel presently, his reasoning is specifically endorsed by both Lord Reid and Lord Pearson.
Yes, so on the facts of this case, I think all the relevant rights and restrictions were to be found in the articles. Is that not right?
That is the case,
and
but
so
here
you
we have...
You have to get, translate or take that step further into the creature that we have here. And are you finding, do you get assistance from other authority, or are we simply invited to make that further step ourselves on the facts that we have before us in this case?
I do get some assistance, further assistance from other authority, my lord.
Right.
And if I can take you there now to volume 1, divider 2. Which is Alexander, and this was a case concerning Mrs. Alexander, who bought a lease of a flat under the right to buy provisions of the Housing Act 1980. She paid a price which reflected a very substantial discount. Under Section 8 of the Act, the lease contained a covenant by which a percentage of the discount amount was payable and was charged on the leasehold interest if there occurred a relevant disposal, such as an assignment of the lease. She died in 1984. For the purposes of capital transfer tax, the district valuer valued the leasehold at £50,000, being £63,000 less a reduction of £13,000 by reason of the covenant to repay the discount. Mrs. A's executors valued the leasehold at £35,400, being £60,000 less the full discount amount. The Lands Tribunal held that the value of the lease without regard to the question concerning the covenant for repayment was £63,000 and concluded that they had no jurisdiction to answer that question as to the discount. The Special Commissioner held that 1, that question was not one of land valuation and therefore fell within their jurisdiction. 2, the liability to repay a proportion of the discount should be taken into account as a current liability as at the date of death, and not as a liability falling to be discharged at a future date. And 3, the value of the leasehold was £38,400, being £63,000 as determined by the Lands Tribunal, reduced by the full discount amount. The Crown appealed and held in the Court of Appeal allowing the Crown's appeal. Under Section 22 of the Finance Act 1975, the value of each item of property of the estate which is deemed to have been transferred is taken to be the value immediately before the death, and that means the value of the property in the hands of the deceased. The liability to repay the discount being charged upon the leasehold was incumbents on the property and should be taken to reduce the value of the property under the Act. The question as to the value of the flat taking in account the liability to repay was therefore for the Lands Tribunal. And 2, in order to determine the amount by which the value of the estate is less by the transfer, the Lands Tribunal is required to determine the amount which, on a hypothetical sale, the person would be willing to pay to acquire the lease, subject to the obligation which would fall on the hypothetical purchaser to make a repayment to the landlord in the event of a disposal within Section 8.3 of the Housing Act, but on the footing that his own hypothetical acquisition did not itself give rise to such a disposal. My Lord, the significance of this is that it shows just how far the step-in-shoes principle goes. So it is in fact impossible for somebody to acquire other than by inheritance, without triggering the liability to repay the discount. And if your Lordship needs to look at the statutory provision to make that good, I don't think it's contentious, but it's in the additional authorities at Divider 10, where we set out Section 8, or Section 8 of the Act is set out.
So which tab of the new bundle?
10.
10, my Lord, and Section 8 starts at the foot of the first page, but the relevant provision, subsection 3, subsection 2 tells us the amount repayable, and it's effectively the whole discount reduced by 20% per annum for each complete year that the property has been held by the purchaser. And then sub 3, a disposal, which triggers the repayment within this subsection if it is a further conveyance of the freehold or an assignment of the lease, or the grant of a lease or sublease for a term of more than 21 years, otherwise than at a rack rent, where the disposal is of the whole or part of the dwelling house, and then certain exceptions which are not relevant.
And subsection 1 makes it clear this is a covenant which is binding on the secure tenant and his successors in title.
Indeed, my Lord, but it will be exhausted if the lease is assigned, because the liability payable under the covenant will have been triggered and crystallised by paragraphs 2 and 3. And as one sees at the end of subsection 1, it applies if within a period of 5 years there is a disposal falling within subsection 3, but if there is more than one disposal, then only on the first of them.
Yeah.
So it is impossible for a purchaser to acquire the property and then be subject to this provision on a continuing basis, otherwise than to the extent that the vendor's obligation is of course secured against the property. But one would expect in ordinary conveyancing for that to be discharged at the point of conveyance. So what the court is saying one has to do here is assume you can do the impossible.
But to understand this case, we do have to look at the bit of subsection 3, section 8 subsection 3, which you said wasn't relevant, which shows that if in fact someone who's bought under the right to buy legislation dies and it passes under that person's will or intestacy, then there isn't a charge and it does go on. And that's what's happened in this case, because Mr. Alexander was the executor and maybe possibly the beneficiary of Doris Alexander, who was the one who had bought.
Indeed, but in postulating, looking at the hypothetical sale, one has to presume that the purchaser buys this property in a condition which the purchaser under that obligation. Now that's impossible.
Well, it's no more impossible than the unrestricted transfer of shares in a private company with big restrictions on transfer.
Indeed, but then having done that, the price that is paid reflects the continuing existence of something which will not apply to a hypothetical purchaser going forward. So the hypothetical purchaser is taking all the incidents of the deceased's ownership of the property.
Yeah, well, certainly there is that point of difference, but this is basically a burden which was charged on the leasehold interest, and it continued after the death of Doris Alexander.
Indeed, my Lord. I accept it is not the same position entirely as we're looking at, but what it tells us about the valuation of that point is that although this obligation can burden only Doris Alexander and her heirs, and can't burden anybody who buys from her, nevertheless it's taken into account in valuation. And as we will see in the shareholders' agreement, if Mr. Gibson died, there are provisions which would benefit his estate.
Is there anything from page 72 that one gets? I don't know what passages you were thinking of, but the obligation to repay the percentage discount actually was a charge on the property.
Until that first sale occurs, and then of course will be satisfied on the conveyance on an actual sale.
It's a charge.
It is indeed, my Lord. If I may take you to page 75, in the judgment of Lord Justice Nichols, at the foot of page 3, at the foot of page 75 in paragraph 3, thus the legislation makes it necessary to identify the value of an estate at a particular time. In short, value means market value, the price which the property might reasonably be expected to fetch if sold in the open market. And then jumping to the last line, the notional sale does not change the subject matter of the valuation. What is being valued is property belonging to the transferor, and it is being valued as at a time when he still owned it. The notional sale is designed merely to identify the sum which a purchaser in the open market might reasonably be expected to pay, and then the important words, to be placed in respect of that property in the same position as the transferor. And his Lordship says this interpretation is consistent, accords with the decision of Crossman. And down at letter F, his Lordship explains to the Lands Tribunal how to actually get at that value. Clearly, in carrying out this valuation exercise, it may well be convenient and sensible for the Lands Tribunal to consider first how much the lease would be likely to fetch if sold in the market, but disregarding the subsisting discount repayment liability, and secondly, the amount by which this price would be likely to be reduced if the notional purchaser who acquired the lease did so subject to an obligation to remake repayments as provided in the lease if thereafter there were to be a disposal of the lease as defined under the Act, or in our case, as defined in Clause 4 of the subscription agreement.
Anything more from that case?
No, my Lord, that is all from that.
Yes.
My Lord, in the interests of expedition, I was going to take your Lordships to Lionel.
Yes.
Lionel endorses Crossman. The Crossman decision was a majority decision. Lionel was unanimous in endorsing Crossman. And if I can simply mention that at page 693... Sorry, I beg your pardon, my lord. It's tab 22, and that's in volume 3. I don't intend to read these passages out, my lord, but if I can just draw them to your attention, I'll give you the page numbers. At page 693, Lord Reid quotes Lord Justice Holmes and Jameson and then endorses the reasoning of Lord Roche in Crossman. And we've seen that was the only place in Crossman where there was a discussion of purely personal rights, so it's endorsed by implication by Lord Reid. Lord Morris at page 696 simply endorses Crossman in very brief terms. Lord Pearson at 703 endorses Salveson reasoning and then endorses Lord Roche in Crossman in particular. And both Viscount Dillon and Lord Donovan merely endorse Crossman without elaboration, so I don't need to take you to those passages. On the question of information, which was the other issue raised in Lionel, as to what information the purchaser would be taken to have and how it would affect the price, Lord Morris at page 698 talks about the prudent investor who knew the relevant facts, and Lord Reid to light effect at 694 letters D to H. But of course, my lords, you've already seen subsection 3 of section 273, which extends or makes it clear that for present purposes we assume what a prudent purchaser would require to be at large. And then my lord, the next authority, and again I'll do the same procedure with this, is the Duke of Buccleuch, which you'll find at divider 14, which I believe is in volume 2. And here I would draw your lordship's attention in particular to Lord Reid's speech at page 525, where he says that one has to carry out the valuation on that particular day, and by reference to the facts on that day. And I would simply observe, on our particular day of valuation, we had an actual arm's length sale of the subject matter, the shares in question, with a third party at a price which we say reflects what could be got for that share on that day.
Sorry, what share on that day?
Mr. Gibson's shares, defined.
I thought there was a sum total paid for all the shares.
But it's divided as per each shareholder in the shareholders' agreement, which we will look at, my lord. And he got the amount which the agreement provided for him to get.
Well, he had to, because that's what
Indeed,
the shareholders between them had agreed.
Well, it's what was also agreed with the purchaser.
Well, purchaser wouldn't give a fig, would he?
Well, I think he would, my lord, because
Why?
if the obligations under the shareholders' agreement hadn't been satisfied, then he would have been buying litigation. The company he was buying, I would submit, being a party to that agreement, would be party to that litigation. There might be actions for unfair prejudice because an agreement between shareholders had been breached, and we'll look at all that when we look at the company law authorities, my lord.
Is the point at the top of page 525 not really this, that you can't get round the valuation problem by saying, oh, well, that was a rather unfortunate day from my point of view because value is rather very high or very low and I'd rather wait to a better date.
Yeah.
You're tied to the statutory date and you can't escape from it. Is that-
And
that's
on the statutory date here, there was a sale by Mr Gibson of these shares to somebody who was an unconnected third party at a price in the contract of sale.
Well, nobody's suggesting there should be any other date in this case.
Indeed, my lord, but to disregard, so that fact on that date is of monumental importance when you know that somebody is going to buy your shares for this amount of money. It tells you the answer. If it were a connected person, if it were the employer paying over the odds for the shares, then that would be a different matter, because you could say, well, this isn't evidence of what the market is. But for whatever reason, the purchasers did indeed think it was worth paying Mr Gibson the amount of money they did pay him. And when we look at the agreement, you will see that there are provisions which point to the importance of the purchaser agreeing to that. Just before we leave...
So the market value of the other shares was what? The less than the average price?
In all the circumstances, yes, my lord.
Well, if you invest the purchaser with all the information which a reasonable purchaser would acquire, what he does know is that in totality he's paying a value for all the shares, and you could look at it in various ways. You could just take each share valued according to the number of shares held, or you could take it according to the value distributed amongst the various shareholders under their agreement. But it comes to the same thing as far as he's concerned in total.
Well,
and he knows he's not selling to Mr Gibson alone.
My lord, if there were two classes of shares here, and more money is paid pro rata for shares of one class than the other, then nobody would suggest for a minute, when dealing with a third party, that wasn't market value. How the third party arrived at the value of one class of shares as opposed to the other, nobody would even bother to inquire into.
Well, this is coming back to the point you keep mentioning, that
Indeed.
you're inviting us to treat the subscription agreement as if it was pari passu with the articles.
Well, it derives its authority from them, but more to the point, if a purchaser decides to buy Mr Gibson's shares and for whatever reason thinks it's a good idea because this agreement is in place to pay the price that's in them, then that's his business and it's the arm's length price, even if the agreement is completely unenforceable and the purchaser's made a mistake. If a majority shareholder in a company bamboozles the purchaser into paying him more pro rata than the minority get, then that's the market price. And it's the market price that the minority get for their shares in that bargain at arm's length on that day. These are the facts on the day.
I don't think you could really seriously submit that a sale induced by misrepresentation would be a fair basis for market value.
Not necessarily induced by...
Well, you did use the word bamboozle, if I heard you right.
I apologise for that, my lord, and I take it back. But if everybody honestly believed that these provisions were enforceable, or even if the purchaser took the view that if he didn't pay this price, he would be buying litigation and it would be a mad thing to do, and it was convenient to pay this price. All these things, we don't know. There is no evidence about why he chose to pay this price. All we know is that there's his agreement. He did. And that is the evidence on the day.
Well,
Now,
is there anything more from the Duke of Vaucluse? Sorry.
very
yes,
quickly, my lord, yes. There was a reference in Lord Guest's speech to putting into the shoes of the deceased. It's the same point, but in Lord Reid at page 530, there is a discussion of whether or not the matter should be sent back for extra evidence, or whether the point that gave rise to that should be excluded. So I just draw your attention to that. On the alternative argument, you may care to reflect on what's said there at page 530 in the paragraph headed, "This matter was never separately investigated by the tribunal." My lord, if I can then take you to Lady grey, Lady Fox's executors, grey. This is divider 20, so in volume 3. This case was principally concerned with issues of lotting. It was a case concerning the valuation of an interest in an agricultural tenancy held by a partnership in which the deceased had a preponderant interest and the freehold being in the deceased's estate. But the value of the decision is the I would submit masterly summation of the principles by Lord Justice Hoffman at page 371. Starting just below letter H, the question is what a purchaser in the open market would have paid to enjoy whatever rights attached to the property at the relevant date. Furthermore, the hypothesis must be applied to the property as it actually existed and not to some other property, even if in real life a vendor would have been likely to make some changes or improvements before putting it on the market. And there's a reference to the passage we just saw in Lord Reed's speech in Buccleuch. To this extent, but only to this extent, the express terms of the statute may introduce an element of artificiality into the hypothesis. In all other respects, the theme which runs through the authorities is that one assumes that the hypothetical vendor and purchaser did whatever reasonable people buying and selling such property will be likely to have done in real life. The hypothetical vendor is an anonymous but reasonable vendor who goes about the sale as a prudent man of business, negotiating seriously without giving the impression of being either over-anxious or unduly reluctant. The hypothetical buyer is slightly less anonymous. He too is assumed to have behaved reasonably, making proper inquiries about the property and not appearing too eager to buy. But he also reflects reality in that he embodies whatever was actually the demand for the property at the relevant time. And I submit that's a particularly relevant passage. It cannot be too strongly emphasised that although the sale is hypothetical, there is nothing hypothetical about the open market in which it is supposed to have taken place. And just below letter D, the valuation is thus a retrospective exercise in probabilities wholly derived from the real world, but rarely committed to the proposition that a sale to a particular purchaser would definitely have happened, whereas we know in this case that a sale to a particular purchaser did happen, and one at arm's length at that.
Does this case help us in forming the bridge between the Articles of Association and the agreement?
No, it doesn't, my lord. Save in the actual demand in this case. So the passage at the phrase sentence at letter B on 372. The hypothetical purchaser also reflects reality in that he embodies whatever was actually the demand for the property at the relevant time. So insofar as the sale agreement shows us how much was paid to Mr. Gibson by the third-party purchaser, that was, we submit, actual demand. And the hypothetical purchaser has to embody that.
I think what Lord Hoffman is really thinking about is the state of the market, which is not hypothetical. You see what the actual market was in such and such a part of the city or wherever the transaction is taking place.
Well, there are in Lionel, my lord, descriptions of markets and particularly the market in respect of private companies where the observations made are to the effect that although the hypothetical open market includes the whole world, in fact, the relevant demand is confined to a few people, very often, particularly so in relation to a shares holding in a close company. And what we would say here is Jewsons were in the market here. We know that from the sale agreement, and therefore the hypothetical purchaser must embody what they were prepared to pay. It doesn't completely solve the problem, my lord, but what I say it does do is link Jewsons to the transaction, whether or not the rights in the shareholders' agreement are personal or run with the shares. Jewsons may have felt that it was appropriate to pay Mr. Gibson the amount prescribed in the shareholders' agreement because that would unlock the sale of the whole company. Without that, he might sit there saying, I'm going to sue the other shareholders, which would be an appropriate thing for him to do, given the terms of the agreement he's got. And that would feed through to the price they were prepared to pay to get his shares. If, my lord, you want, there are surprisingly few authorities on the question of market value, but if you want an example of an authority, of a case where one of the parties used his superior bargaining power to get a good price from another, and then subsequently claimed that was less than the true market value. Bullivant is such a case. It's in Divider 6 of Volume 1. I don't propose to take your lordship to it because it's a rather narrow point, but what it does illustrate is that the marketplace on any particular day reflects the actual transactions which go on, and market value can be what somebody cajoles, forces, leverages out of somebody else for whatever reason. There were particular facts in that case, and I don't think it takes us much further in relation to the articles here. But there are dicta there which talk about what's an arm's length transaction, and that's really what that case was about.
Yeah.
But if one accepts that the transactions were at arm's length, then it follows they were at market value, and that was what the practical implication of the decision was. There's a passage towards the end of Mr. Justice Ferris's judgment in that case where he says that one of the characteristics of an arm's length transaction is where one party takes advantage of his position to get a better or the best possible result from another.
Now, we're reaching 4 o'clock. Are there other authorities that you were proposing to take us to?
On the estate duty line, no, my lord. What I was planning to do next was to take you to the texts and authorities relating to company law.
Well, there's
So
rather
there are
alarming
three
lots still to
cases I would
go.
like to take you to.
Could you just give the names of the cases so
Yes,
we know
indeed. They are in the additional authorities, Cumbrian Newspapers Group Limited and Cumberland and Westmoreland Herald Newspapers and Printing Company Limited. That's at Divider 2 in the additional authorities. And that's authority for the proposition that rights under the articles which apply to a particular named shareholder can be class rights for so long as that shareholder holds shares.
Yes.
Harman and BML Group Limited, which is at Divider 3 in the additional authorities bundle. And that is authority for the proposition that a shareholders' agreement can contain rights which attach to the shares.
Yes.
O'Neill and Phillips, which is at divider 23 in volume 3. And that, I say, is authority, amongst other things, for the proposition that the remedies for unfair prejudicial action, section 459 of the Companies Act 85, which was in force at the relevant time, may be invoked where an agreement between the shareholders is not honoured.
Yes.
And then, my Lord, in the additional bundle at items 4, 5, 6, 7 and 8, all of which are very short extracts from textbooks, but which are all broadly to the same effect, that the rights attaching to shares are to be found in the memorandum, the articles, and the terms of issue of shares.
Yes.
And that the terms of issue may therefore, in effect, create class rights. The reason no authority is cited for that proposition is that we couldn't find any, but the frequency with which the textbook writers say that or something to that effect, or some of them say part of it, some of others say part of it, suggests that the proposition is almost trite law.
Well, we'll have to stop now. Mr. Johnson, how long do you estimate you're likely to need?
Well, I think it's still reasonable to say an hour and a half.
Well, we may need quite a lot of assistance. I think we should assume, really, to give you a chance to address us and to give a right of reply, which of course you'll be expecting. You really must try to finish by 11:30 tomorrow. If we start at 10:30, you really have to compress the rest of your argument in that time.
My Lord, I will certainly.
Well, it's not just strive, it's pretty well an instruction to make sure you do that. Very well, 10:30 tomorrow morning.
That's not the reason.